I'm Demaya Milligan, and today we're going to be talking about music remixing and music sampling within the music industry, and also how these components are protected under IP, or as we know it as intellectual property. I'm going to try to give you all a couple of examples of some successful artists that have made a great career from specifically remixing and sampling others' music. Also, I'm going to try to break down the process of how you register music that is sampled or remixed at all. But first, let's talk a little bit about IP and what is intellectual property. In the music industry, music remixes and samples have been pillars for the evolution of not only music itself, but also for intellectual property. Intellectual property describes and breaks down exactly how remixing and sampling are protected in the U.S. by one specific law, copyright, which happens to be one of four types of IP, intellectual property. Under copyright law, we will explore the difference of how it protects creative works versus the music itself, and how remixing and sampling fall under these rules. When discussing intellectual property, there are four branches that break down and explain precisely what it is. We have patents, trademarks, trade secrets, and copyrights. Patents are used to protect useful things that people create or invent. Trademarks are used to protect brands. Trade secrets are used to protect family recipes or business secrets. And copyrights are utilized to protect creative works, original works, and music. When discussing the protection of original works and/or music, it's important to know that the music itself, including the lyrics, the musical composition, and the sound recording, are all protected under copyright law. Copyright law of the United States and related laws are contained in Title 17 of the United States Code. It includes the Copyright Act of 1976 and all subsequent amendments to copyright law, the Semiconductor Chip Production Act of 1984, and the Vessel-Huell Design Protection Act. The Copyright Act of 1976 law is the basic framework for the current copyright law and was enacted on October 19, 1976. The 1976 Act was a comprehensive revision of the copyright law in Title 17, and the Copyright Office is responsible for registering intellectual property claims under all three that I mentioned earlier. As stated in Copyright Basics Circular 1, copyright is a form of protection provided by U.S. law to authors of original works of authorship from the time the works are created in a fixed form. This circular provides an overview of basic facts about copyright and copyright registration with the U.S. Copyright Office. But let's talk a little bit about authors' rights that are protected under copyright law. There are four main rights that copyright law grants each author. Those are the right to reproduce work, the right to transfer work, right to perform or display work, and the right to make new creative works based on original work. So what exactly does the author's rights have to do with remixing and sampling within the music industry? When deciding to use a work protected by copyright, the general rule is to seek permission from the copyright owner. Under the copyright law, a copyright owner may authorize activities that fall under the exclusive rights of copyright. The first step to take when obtaining permission to receive a license of a copyrighted work is to first research the copyright status of that said work. Once you do that, the second step is to contact the copyrighted owner. The contact information for the copyright owner may be found in the office's records, or you may need to contact the organization that published the work. An application for copyright registration contains three essential elements: a completed application form, a non-refundable filing fee, and a non-returnable deposit, that is, a copy or copies of the work being registered and deposited with the Copyright Office. In discussion of the rights that an author has to their copyrighted work, these exclusive rights are subject to certain limitations established within the copyright law. Fair use is one of the more commonly known limitations. Fair use is a legal doctrine that promotes freedom of expression by permitting the unlicensed use of copyrighted or protected works in certain circumstances. The Fair Use Index tracks a variety of judicial decisions to help both lawyers and non-lawyers better understand the types of uses courts have previously determined to be fair or not fair. Courts evaluate fair use claims on a case-by-case basis, and the outcome of any case depends on the fact-specific inquiry. This means that there is no formula to ensure that a predetermined percentage of amount of a work or specific number of words, lines, pages, or copies may be used without permission. One of today's artists that we all kind of know and love, who has mastered the art of remixing and sampling and utilizing that to base their career off of, would be Saweetie. Saweetie is an American rapper, singer, and songwriter. After the release of her debut single, Icy Girl, which earned an RIAA Platinum certification, she was signed to Warner Brothers and then her manager Max Goose's record label, Artistry Worldwide. Saweetie is just one of many artists who have utilized remixing and sampling to form and shape the kind of sound and music that they make within their career. And she too had to go through the legal processes when it comes to utilizing copyrighted work to create it in her own. So in conclusion, remixes and samples are protected under copyright laws, which is a type of IP, intellectual property, an area of law that protects the things that humans create. Hopefully this video has encouraged some of you today to go and register some of your own creative works that you haven't gotten a copyright for. And if you need help, here's the link and information to how to properly register for a copyright. Thanks.